मुझे मालूम है कॉलेज These appeals are at the instance of the state of West Bengal and arise out of two prior rounds of litigation wherein the state suffered judgments against itself. We have extensively extracted the relevant submissions made across the bar, and we have of the considered view that certain questions which arise for consideration, there are 13 in number, which we have, which we'll read. What is the scope and extent of the power under Article 309 of the Constitution of India? What is the scope and extent of the rules framed by the apparent state, that is ROPA rules, and the first memorandum dated 23rd of February 2009? Whether the notifications of official memoranda issued subsequent to the clarificatory memoranda dated 23rd of February 2009, that is 9th of December 2009, 6th of April 2010, 23rd of October 2010, 12th of December 2011, 31st of December 2012, 16th of December 2013, 9th of January 2015, and 14th of December 2015, issued by the apparent state revising the rates of DA are in consonance with the ROPA rules. Given that the definition of existing emoluments in ROPA is identical to the central government rules, that is legislation by incorporation, could the state have then deviated from the index being adhered to by the central government? In other words, was the incorporation of AI's CPI number a one-time measure? Whether DA as a concept is static or dynamic, and whether by the act of the legislation recognition of a particular index does the character thereof change? Whether the actions of the apparent state are vitiated by manifest arbitrariness, as also negatively affecting the legitimate expectation accruing in favor of the employees. Whether adoption of the AICPI would render the distinct legislative domains under List 1, Entry 70, and List 2, Entry 41 OSHO. What is the impact of the direction of the tribunal for the state to follow the AICPI insofar as the financial autonomy of the state is concerned in the federal structure of the country? What is the effect of the findings returned by the High Court in its first round of litigation? Do the respondent employees have any right to receive DA twice a year in line with the pattern of the central government? Is financial capacity of the state a ground available to deny the payment of DA if under the existing rules the same is held to be a legal right? Since the question involved in this list is the payment of DA, which is an aspect of fiscal policy of the state, what is the extent of judicial review which is permissible? Can DA be said to be a fundamental right under Article 21 of the Constitution of India as held by the High Court? The claim of the respondents is for a period 2008-2019. However, the legal redress of the alleged grievance was only initiated in 2016. Was the claim of the respondent affected by delay and latches as such able to be discussed? Now, these are the questions which in our considered view, which arose for consideration before this court. And we have answered one by one. We just briefly, we understand this morning and we also have to go to the court, but we'll tell you. We have said that Article 309, we have extensively discussed, and the principles enunciated are non-exhaustive. One. Questions number 2 and 3, we have come to the conclusion that in some it is hereby concluded that DA by its very nature is non-static, fluid and subject to change. How that change is to be carried out is through the ASCPI. The first memorandum is also the subsequent memoranda fall prey to the fatal flaw that they do not make reference to the ASPI, which is absolutely essential to the determination of the DA, which in turn is indispensable to the computation of the total amount of existing emoluments. As a necessary follow-up thereto, it would be observed that the incorporation of the ASCPI cannot be termed as a one-time measure, and once DA was defined using it, to take a different path would be impermissible in law. So questions 2, 3, 4 are answered accordingly. Now, insofar as question 5 is concerned, it has got two facets as we read. One is with regard to the arbitrariness on the part of the state, and the second is with the legitimate expectation of the employees. And all these, on both these issues, we have said that keeping with the judgments referred to above, the principle of manifest arbitrariness under Article 14 refers to legislation that is capricious, irrational, lacking reason, principle, or excessive and disproportionate. Such arbitrariness vitiates both subordinate and plenary legislation alike. In the present fact, since the legislative exercise did incorporate the SCPI into the framework, deviation therefore from without any basis or discussed above falls in the lacking of reasoned principle, prong to manifest arbitrariness, passed from legislative competence. For the apparent state to have deviated from the recognized position to something else without laying the groundwork, therefore compromises the exercise of rendering it capricious. So that is what we have read. Insofar as manifest arbitrariness is concerned, we have further elaborated, and we have held that it is not so, in view of Hakamchand Supra, which you had referred to. And insofar as legitimate expectation is concerned, we have said that, of course, it cannot be unless it is by rule of law. And we are of the view of that in the light of the principles referred to above, the legitimate expectation on the part of the respondents did arise in view of the change in the position of law. Otherwise, there is no legitimate expectation. Enactment of ROPA and its recognition of the LCPI as the determining factor for the computation of DA. Now, question number 6 and 7, whether there is any conflict in between the list 1 and list 2 of the schedule. We are of the view that this question does not arise in our considered view at all, and therefore we have said that there is no conflict. These both are coextensive and work in a totally different plane. And the next question we have said is that the alleged conflict in our considered view is a figment of the imagination of the apparent state. The argument seems to have been conjured up in thin air. Where is the exercise of the power of the union, legislative and executive imposing any conditions of the apparent state? On the contrary, the power exercised is only by the apparent state through the governor, permissible under the constitutional scheme in terms of Article 309 of the Constitution of India. Now, coming to the effect of the finding of the first round of litigation, we have said that yes, it has conferred a right on the employees. Whether the respondents were entitled to DA twice a year. Here we are in agreement with the submissions made by the appellants that DA cannot be given twice a year. So to this the appeals are allowed. Now, fiscal policy and judicial review. We have elaborately discussed that once there's a right which is conferred upon a person, then fiscal policy cannot be come in the way of the disbursement of such rights. Now, whether dearness allowance is a fundamental right, we have said that in terms of the impugned, because it was not given up really, in terms of the impugned judgment, the High Court held the payment of DA was a facet of Article 21 of the Constitution of India. Before this court, however, the opposing parties have jointly agreed that none will press this question either way. That being the accepted position, we do not give any finding thereupon and leave the question open to be decided in an appropriate case. So the appeal is allowed to that extent also. Now, whether there is delay in latches, we are of the view that the employees have been relentlessly pursuing the matter before different fora. So therefore, their legitimate claim, which is recurring in nature, we're giving a fresh cause of action every moment, cannot be said to have been delayed, cannot be denied on account of delay in latches. Now, the directions part we have read is this. I propose to the above we pass the following order. The appeals are partly allowed on two issues. To receive dearness allowance, page 128. To receive dearness allowance is a legally enforceable right that has accrued in favor of the respondent employees of the state of West Bengal. Given its incorporation in ROPA rules, the AICPI is the standard to be followed by the appellant state of West Bengal for determining of existing emoluments. The employees of the appellant state shall be entitled to receive the arrears in accordance with this judgment for them from the 2008 till 2019. On 16th of May, we had passed following interim order. We have extracted that interim order where we had said that some amount be immediately dispersed. The interim directions issued are herein shall be complied with immediately. On account of subsequent change in law, if any amount that would be dispersed in compliance with the judgment shall not be liable to be recovered. Considering the financial implications involved and also recognizing the need for structured release of the funds so as to not prejudicially impact state's exchequer, while at the same time balancing the rights of the employees to receive the emoluments due to them, we find it fit to constitute a committee to monitor the implementation of the directions herein above as follows. We have requested Honorable Ms. Justice Indu Malhotra, a former judge of this court. We have also requested Mr. Trilok Singh Chauhan, former Chief Justice of Jharkhand. We have also requested Mr. Gautam Madhuri, also a judge of retired judge of Chhattisgarh, and along with them, the Comptroller and Auditor General of India, or senior most officer in his establishment nominated by him. The import of the committee shall be in consultation with the state authority to determine the total amount to be paid, schedule of payments within which the state shall be bound to follow, periodically verify the these of these amounts. The exercise to determine A and B shall be carried out before 6th of March 2026. The next consequential step, that is the payment of first installment, subject to the determination of the committee, would be paid before 31st of March 2016. The committee shall be accorded all facilities and privileges, including all necessary logistical arrangements. Expenses shall be borne by the appellant state. Insofar as the remuneration is for the committee members is concerned, we leave it to the wisdom of the chairperson. It stands clarified that those employees of the state who have retired in dependency of this litigation shall also be entitled to benefits in accordance with law. Let the appellant state, after payment of first installment, file a status report indicating the determination made by the committee, the schedule adopted, the status of the first payment, list on 15 May for compliance. These pending applications also stands.
Grateful. Very good.
My lords, the employees are extremely grateful.
We'll only say we have rendered justice, that's all. Right or wrong, good or bad, we don't know.
Actually,
chairperson लिखा है ना.
grateful.
Thank you, Madam.
Very.
But for you, we wouldn't have been able to, and my Lord's contribution, largely.
Your Lordships have burnt the midnight oil, but we have only worked till 10 p.m. or till 11, Your Lordship.
No, you have also burned midnight.
You don't know how much my Lord
effort we
had to,
We appreciate, Buddha.
Grateful. Very good. Very good.
Thank you.
Item 1501.
For the reasons recorded herein above, we are of the considered view that the impugned judgment is reasoned and borne out from the material on record, except to the limited extent expressly modified therein. This court does not find any ground to take a different view from that taken by the High Court. Accordingly, the civil appeals are dismissed.
Thank you.
Item 1.
Lord, before your lordship begins the bench, Lord. Lord, the British motor case,
that-
104 is wrong. They said, yesterday, lordship, adjourned to 17.
We realize that it has to.
Lordship may direct the registry to,
We'll do that. I think the order needs to be corrected.
yes, because it has gone to 17 because lordship is sitting in the combination.
Order needs to be. Today it is listed, na?
104 it is this.
Ma'am, just wait. Just can you wait?
I mean, your lordship, then. I just
no,
thought
we'll
I'll
do
take
that.
your lordship notice.
We'll do that. What we are saying is that the item come.
Yes, yes, we'll do
You
that.
are here only.
Yes, yes, my lord.
You are one of those
It is a pleasure.
who never leaves the campus of the Supreme Court. just
It is a pleasure, my lord.
your affidavit have you filed?
Yes, madam.
I mean,
Affidavit, second of pleasure, your lord.
Malords, we are,
Very short affidavit I
we
have
give, Malords, we undertake to Malords provide the requisite undertaking before the jail superintendent.
But,
In terms of the affidavit.
But I fail to understand why a 32 and why a writ petition.
No, Malords, because there are multiple FIRs.
It's okay. You
different
have
cases.
been granted bail in number of cases.
Malords, otherwise, Malords.
Otherwise, this will become a trend that file a 32 petition and get bail.
No, Malords, in this matter, Malords, because I would have been required because of the medical condition.
So
which
here
was an
recently,
emergency.
I was going through this order 212024. You have been granted bail in one case.
That's right, Your Lordship. But in this case,
No,
Malords,
so
I
why
would
to
have been-
bypass that remedy? Then it will become a trend. Everybody will file a writ petition, get a bail, and then if that petition is dismissed, come to this court
Malords, we went into 26 only for this reason.
for bail.
On-
For bail.
Malords, we went, Malords, only for this reason that at 4 different cases, I would have been required.
How many FIRs are there against you?
Malords, total Malords cases in which Malords I am in custody. Total FIRs are 21, in which 9 I have been acquitted. 12 are the pending cases.
And in 12, how many cases you have?
8 bails I have already got.
So how many are left?
Only Malords 4.
4. So you can, if the court has granted you bail in 8 cases, 4 again the court will grant you if there is no material.
Malords, I will be required to Malords go to Chittorgarh, Malords Bali, Jaipur, and Malords one more place.
the interim bail is for how long? For what period?
Malords, we are requesting a Lordship for 3 months.
3 months medical treatment for 3 months.
Malords, because I am the only Malords parent.
One minute. According to you, what is that you said?
But if a lordship will have this affidavit dated 2nd of February, or not? 2nd of February,
Yes.
very short affidavit on behalf of
Where you have said that he will furnish the details of the hospital where his wife will undergo treatment surgery.
in 3 months.
So what is the period which you have suggested here?
Or period, any reasonable period, whatever you want to say. On period, I have not said anything.
Maximum surgery will take how much time?
My lords, surgery will not, my lords, if the post surgery, my lords, recovery will take, my lords, about 2 months.
Oh, what we'll do is we'll give you 4 weeks time for this. And should there be, depending upon the further requirement, then you move and
My lords may have it for 45 days, my lords, for the reason that I am the only parent, my lords. My parents are not alive, my wife's parents are not alive. There is nobody in the family.
we have perused the affidavit filed by the
45 days.
We have perused the affidavit filed by the state. In principle, state has no objection to the grant of interim bail.
Your medical and humanitarian.
In principle,
Yes, ma'am.
for the reason that petitioner's wife has to undergo undergoes surgery,
And there is an 11-year-old child.
and there is none else in the family of the petitioner to attend to her. More so when there is a 11-year-old child born through the wedlock. In these attending facts and circumstances, we allow the application in the following terms. A, the terms and the conditions set out by the terms and the conditions as the state has referred to in para 5 of the affidavit shall be strictly adhered to. The interim bail, the period for interim bail shall be for 45 days from the date of release. The petitioner, not during this we clarify